I got to do the opening again. Hello, everybody. It's the American Doofus Show. I'm your host, Barry Welsh. Don't be a doofus. And you can contact me at Facebook at American Doofus, or you can email me at americandoofus@gmail.com. Dave Blackford's back with us, attorney from Louisville, and we're going to basically do an update on where we're at as far as the legal process. We know the consequences of the Breonna Taylor case, all the way to NFAC and the Angry Viking facing off, according to mainstream.
We're not facing off.
According to mainstream media. But the legality of it, I'm concerned that Louisville still is going to explode, that nothing's going to happen to the police officers. Where are we at now in the case? Where's the case stand from where we're at right now?
Okay, so procedurally, we're at the grand jury, okay? And what that means is the prosecutor is going to present the facts and evidence to a group called the grand jury, and they are going to determine whether or not there is probable cause that a crime was committed, okay? And if the grand jury returns what's called a true bill, okay, that means that there will be a criminal case taken out on whichever defendant they find has committed a crime based on a finding of probable cause based upon the evidence presented by the prosecutor. This is not an adversarial situation, meaning there's no defense attorney there, okay? The defendant won't be there, or the suspects, as you will. They won't be there. The judge won't be there. It's just the prosecutor, the grand jurors, and then whatever witnesses come forth, okay? Now, there could be a lot of witnesses, all right? I don't want to get into the facts or anything right now. I just want to get into the procedure.
Right.
So normally what happens here in Jefferson County, you and I were driving down the street and we have 5 pounds of weed in the glove compartment or in the trunk, or we pop the door panels and we got it in there, right? We get pulled over, dog searches it. Right there, the cop finds the weed. We're both in the car. We don't know whose it is. Constructive possession. We're both there in the car. They will arrest us right there. They will write the citation out right there. That would be your charging document, your affidavit, if you will. And then you'll go to jail. You'll get arraigned. Once you're in jail, you have to be seen here in Kentucky 48 hours after your arrest. We usually do it overnight, the next day in the morning. And then that's how that works. Then eventually you'll have what's called a probable cause hearing. If probable cause is found, then the judge will say probable cause is found. We send this case up to the grand jury, and that's how it gets at the grand jury. Okay, then once you and I...
That's where we're at now, right? The case has been given to the grand jury?
Correct. And I want to show the difference between the normal process of how a criminal case gets to the grand jury and this case, okay? Because there's differences, all right? There are huge distinctions here. So then if we're at the grand jury, we're not there. The prosecutor puts on the evidence, says we pulled them over, they had weed in the car, they were both in proximity of the marijuana, and they'll return a true bill. It's called a true bill. If they don't find that there was probable cause that a crime was committed, they'll return what's called a no true bill. It usually lasts 10 minutes, 20 minutes, right? Now, that's us. That's the normal. That's you and I, the normal citizen that gets arrested by the police. That's what happens. Or even just cited by the police. That's the way it goes, okay? However, in this case, we have these officers, and I don't know how many officers there are. I guess Cosgrove, Hankinson, and Mattingly, we definitely think there's evidence being presented to the grand jury for them. There may be others. We don't know those facts right now. We do not know what the Attorney General is presenting, who he thinks could be culpable or who isn't culpable. We don't know that, okay, for sure. We are just speculating, although I think I have my opinion of what I would do if I was him. However, so now they're saying that it's going to be could be a 2-day process, which is crazy because whenever there's a grand jury, the joke is that if a prosecutor wanted to indict a ham sandwich, he could. Okay, that's because there's no rules of evidence. Okay, there's hearsay is admissible. Everything can go in. Okay, they usually don't call a lot of witnesses. They usually present the bare minimum evidence to return a true bill or an indictment, because that's all you need. Okay, and it doesn't have to go on forever and ever and ever. However, in this case, it seems like there's going to be a lot of witnesses presented, and this is what happens whenever a cop is going in front of the grand jury. They did that to Darren Wilson down there, the man who shot Michael Brown in Ferguson. All right, the cop who shot him, they got off, and it was because, you know, there was like 40 some witnesses out there that he put all these people in front of the grand jury. Okay, and what that effectively does is the prosecutor then gets to tell the people, hey, it's not on me. I presented the facts to the grand jury. Now, is it a bad thing that the prosecutor does that in a vacuum? Is it a bad thing that the prosecutor puts on all that evidence? Because there could be mitigating evidence. There could be exculpatory evidence. Exculpatory means something that proves that you're innocent, right? And then there could be, you know, evidence that's bad for you. But normally they don't put all that on. They just put on the bare minimum to return a true bill or an indictment, and you call it a day, and it goes, and then you are formally charged. There is, there's a bond set for you, or maybe not. You'll get an arraignment date, all these things. But in this instance, he's going all out and using every single one of all of his discretion. Whatever he wants to put on, he can put on, right? So that doesn't bode well for anyone being charged, other than one person, and I'll get to that in a minute. So we should all be afforded that. Every citizen that's ever been put in front of a grand jury, anyone's case who's ever gone to grand jury, you would hope you would be extended the same type of scrutiny that these police are being afforded, right? But it doesn't work that way, because you get the charge and they got you in the system, and then you go from there. And it doesn't mean that you're guilty or innocent at this point in time. You've just been indicted, okay? Right. Then you got to go through, you know, the normal process of post-indictment, which would be, you know, normally they'll offer a plea deal. You say, no, that's weak. You try to get a better one. If you can't reach an agreement, you go to trial. And then trial is a whole different level of proof. A criminal trial is the highest level of proof that the state has to provide to the jury in order to prove that you committed the crimes you're charged of beyond a reasonable doubt, okay? But the grand jury is just a probable cause finding. So that's really low.
That's where we're at
right now, yes. Oh, and jurisdiction-wise, it happened in Jefferson County, and the grand jury is pretty secretive. So people are like, well, where's the grand jury? It's in Jefferson County, okay? It's just we don't know when or where, because that's just the nature of the grand jury. And
justly so it can't be influenced, right?
I mean, at this point in time, after 6 months, everybody knows about it. It's not like it's something that, I mean, if you haven't heard about this in Jefferson County, you know, I don't know what you've been doing.
Yeah. Is the report the police put out, the 34-page report, is that will that be in front of the grand jury? Is that the purpose of that report?
Are you talking about the report on the criminal syndicate or whatever they were saying?
Yeah.
I mean, he could put any, like I said, he has full discretion to put anything he wants in front of the grand jury. Very rarely will a prosecutor tell the jury to return a no true bill, meaning don't indict him. Like, here's everything you know, don't indict him, let this die. That's rare. Most of the time, it's like a formality. You know, it's just, hey, here are the bottom line facts needed for you to return a true bill, and for me to indict, for the state to indict this citizen, right? So that's how that works. So whenever they're going this far out, you know, it seems like the prosecutor is doing more than he normally does.
Okay. All right. So do you think, in your legal opinion, is somebody going to be charged?
I mean, this isn't my legal opinion. This is my sociological opinion here. Okay. I think that he's doing everything he can, Daniel Cameron, is doing everything he can to give the officers the benefit of the doubt, and provide evidence that makes the grand jury scratch their head and say, you know what, they were justified. I think he's putting on defenses. I think he's going to paint a more complete picture with all the evidence than most people would ever get at a grand jury hearing. However, Brent Hankison is the one I think. Here's the problem that we have right now. Just us talking about this, we don't know all the facts. We know a lot of speculation. Okay, we know a lot. Oh, they said that Mattingly was struck inside the home, and then well, there was no blood inside the home, says this person, and then somebody else says he was drug out of there, and he said no, I scooted out on my butt. If you get hit in the artery, femoral artery, you bleed out. Like, we don't know any of that. That's all speculative, right? And if we sit here, we make a definitive statement one way or the other, and it turns out that those facts are not true, we look foolish. Okay.
Right.
But
we don't want to do that.
So no, I don't want to do all that. I really don't. The facts we know are this: they had a no-knock warrant that was later changed to a knock and announce warrant. There are some witnesses that said they didn't hear them say police. There was one witness who said they heard them say police, police twice, and then nothing after that. Kenneth Walker had his charges dropped. He said he didn't hear it. He said there was banging at the door. They screamed out multiple times, who's at the door, who's at the door? No one answered. Door flies open. Walker fires. We don't know if Walker's bullet hit Mattingly or not. There's no way of telling that at this point in time because we don't have the facts. So that's what all the stuff that's going to be presented, and all the witnesses were there. They'll probably be called. I mean, or not, or Cameron can just be saying it's going to be a 2-day thing. Goes in there and indicts the ham sandwich. Call it a day, right? But that still doesn't mean there's a conviction at that point. You've just found probable cause to indict them, right? But the way I see it is he's doing all this so he can put it on the grand jury when no true bill comes back. But the one guy who I think could already have been charged is Brent Hankison, and I'll tell you why.
Okay.
So when he was fired by LMPD, now remember, I broke it down how, like, if the police see you do something, they can write an affidavit. The police can write an affidavit on you if let's say that, like, I came over to your house and I set your front porch on fire and you saw me and you got video. I didn't get arrested on the spot. Like, you presented that information to the police department where you live, and they looked it over, and then they issued an affidavit, and a warrant was put out. So they take the affidavit, they write it down, they take it to the judge reviews it, says, yes, there's probable cause in this fact pattern for me to issue a warrant. Then the issue for your arrest is out. And you either get picked up on the road, they come and find you, or you turn yourself in, right? And then this whole process starts, right? Well, when Brent Hankison was fired, okay, the public integrity case number 20.019, all right, and this is coming from Robert Schroeder, who I guess was the chief of police then, and Greg Fisher. This is on June 23rd. He says, in this letter, firing Hankison, it says, I have determined you violated SOP, blah, 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 when your actions displayed an extreme indifference to the value of human life, when you wantonly and blindly fired 10 rounds into the apartment of Breonna Taylor on March 13th, 2020. These rounds created a substantial danger or death. It doesn't say risk. So it says these rounds created a substantial, should say risk, of danger or death and serious injury to Breonna Taylor and the 3 occupants of the apartment next to Miss Taylor's. I make my determination pursuant to the preponderance of the evidence. Now, preponderance of the evidence, remember, that's a higher standard than probable cause. And all you need in an affidavit is probable cause, okay? Now, let's look at KRS 508.060, which is wanton endangerment in the first degree. Okay, so the statute reads as follows. A person is guilty of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. Wanton endangerment in the first degree is a Class D felony. Okay, so that firing document tracks that language. It uses that language.
Language.
They basically used that statute as a template and then filled in the words in between that statute, right? So clearly, if the police wanted to already, they could have already charged him because they said, we found this by a preponderance of the evidence. Well, that's a higher standard than probable cause. So they could have used that, what they wrote, as an affidavit to put out a warrant on Hankerson. However, here's why they haven't done it yet. Because they were waiting for the ballistic reports, all right? So the ballistic reports are important because you can't charge somebody with murder or wanton homicide or wanton murder, which is what we have here in Kentucky, which kind of tracks that same language, except instead of causes substantial risk of serious injury or death, it just says, and you did cause death of another person, right? So Taylor was hit multiple times. Hankerson shot 10 times. So in order to charge him with any of the murder statutes, they would have to determine that a bullet fired from Hankerson's gun actually hit Breonna Taylor and that bullet was fatal. Okay. So that's why I don't think that you saw Hankerson get charged with anything yet. Now, you can argue that for what you want, and you can say, well, what the hell? You charge him on the wanton endangerment, get him off the street, lock him up, put him in the system, and then once you get the rest of the reports, you can amend the charge up, right?
Yeah.
Look, I'm not LMPD, I'm not Tom Wine, I'm not the Attorney General, I'm not the man, I'm not the government, right? I don't know why they didn't do that. If it was me or you, though, they probably would have done that, okay? So I think that if anybody is going to get it, okay, it's going to be Hankerson based on those facts, because we know those facts, okay? Then that's the account of the LMPD. You understand? But but Tom Wine said, you know what? Too close to this. Special prosecutor will let it go to the AG. So that's where we're at right now. So,
where is for those that don't know, I do know, but where's Officer Hankerson now that he's been fired?
I don't know. I haven't been paying attention to that, honestly.
He got hired by the Cincinnati Police Department.
Oh, he's up in Cincinnati now?
Yeah.
Sounds about right. That's what they do.
Yeah.
You get fired here, you go to somewhere else and go menace that society, man. It's a shame. I think there's a name for that. I think it's wandering police. Like you wander from department to department. You know, it's a thing.
Okay, we're doing this at 4:28. It's 4:28 right now as I'm recording this. Is there any chance this comes out like when there's bad news, politicians want bad news coming out at 5 o'clock on Friday when they're when they've hit the freaking road, nobody can get to them.
Yeah, it's called a news dump. Yeah, it's a news dump. I mean, if it's bad news, it would probably come out on a Friday afternoon for sure. But I don't think it's going to happen today. But who knows? I'm not privy to that.
Yeah.
They said next week. You know, I think that's what I heard. I saw that here in the local news.
Okay. All right.
The local news. One thing about the local news when it comes to the law is you take that with a few grains of salt.
Okay. All right. Well, we'll do this again when we find out what the verdict was from the grand jury. We'll kind of track this as it goes legally, if that's okay with you.
Yes, sir. That's fine.
All right, man. Take care of your back. We'll see you next time.
All right. Peace, everybody.
I love you, brother. It's the American Doofus Show. I'm Barry Welsh. I'm your host, and it's still a dark world. Try to be a light. Don't be a doofus. Going to be live tonight at 9 o'clock. See you then.